political parties, that is DP, we have KANU, we have ANC, we have ODM, we have EFP, we have PDU, and we have Wiper in the house. So without so much further ado, I'm just going to kindly request that maybe we can just introduce ourselves in the chat box so that we can know who is in the house, even as we start immediately with the presentation, so that we can ensure that we have at least time to go into the discussions of today. So without so much further ado, let me welcome our moderator for today, Chepkoech Towet, to welcome Honorable Luanga and Boniface Makolwal, and then now we kick off the process. Chepkoech, if you can hear me.
Thank you so much, Maureen, and thank you so much to CMD also for organizing this meeting. It is important for political parties to be involved in the dispute resolution mechanisms. We have with us Honorable Luanga, as Maureen has mentioned, and she is going to make her presentation from the PPDT, as well as some contribution from Boniface at ORPP. So as you introduce yourselves in the chat box and also give your contributions, if you have a question, maybe you might just raise your hand or write it in the chat box. I will note all of them and present it to our presenters of today. So welcome and have a good time. Back to you, Maureen.
Thank you so much, Chepkoech. Maybe I'm just going to call Bon Makolwal from ORPP to just say hello to everyone before I give it to Honorable Luanga. Bon Makolwal, if you can hear me, good afternoon.
Yes, good afternoon to all of you. Glad to be part of this conversation, and as we did it in the morning session, we are here representing the Office of Registered Political Parties for any clarification and any discussion that we'll have. But we are glad to be here and be part of this discussion. Thank you so much.
Thank you so much, Bon. We're happy to have you. Honorable Luanga, if you can hear me.
Yes, I can hear you.
Good afternoon. Maybe you can say hello to everyone before we go into the presentation.
Good afternoon, everybody. Thank you so much to CMD and their sponsors for facilitating this occasion. On behalf of the Political Parties Dispute Tribunal, we are very excited to have this opportunity to be able to engage with representatives from political parties on this issue of the model guidelines, which, as Maureen has already stated, were first developed in 2017, just shortly before the 2017 general elections. So I look forward to the discussion.
Thank you so much. Maybe now we can go into the presentation. Let me project this. I hope everyone can see my screen.
Yes, we can.
All right, Honorable Luanga, I think we're good to go.
Okay, thank you again. Of course, the issue of political parties disputes resolution is something that we have discussed for a long time over the years. And I'm glad that Makolwal of the ORPP is here, because he is one of the institutional memories of the journey that the country has walked towards trying to build capacity for political parties to be able to address issues of disputes. Because naturally, when you bring a team of people together who are supposed to form a common agenda, work towards a common ideology, there are likely to be disagreements or issues that may arise that take time to settle on. And this may lead to, of course, disputes. And then there's need for dispute resolution. And in addition to that, the recognition that with the current constitutional dispensation and the laws, we do intend to have political parties that are organized, that work as public institutions are expected to work, with the principles and values that we anticipate. And that, of course, means the rule of law, and also that they run in an orderly manner. So therefore, I will begin by giving the framework that lays foundation for this dispute resolution. And the first one, of course, naturally goes to Article 91 of the Constitution of Kenya 2010. With that particular article in the Constitution of Kenya, political parties are required to promote the objects and principles of the Constitution and the rule of law, meaning that things should not just happen haphazardly within political parties, but there's expected that there's meant to be some process, some procedure that is laid out, that is anticipated. Remember, if I digress just for a second here, that in this country beforehand, we used to have what people call litigation by ambush, so that you would not know what somebody's case, the details of somebody's case was before the case was presented. But under the current constitutional dispensation, with the principle of rule of law, it is anticipated that all the processes that we put in place are things that people know and they will then adhere to. It's not about surprising people. So that is what is also expected of political parties. Now, when you move from the Constitution and you come to the mother law in as far as political parties are concerned, which is the Political Parties Act, you find that under Section 9(1), and of course, under the second schedule of that particular Political Parties Act, political parties are required to have a constitution and to have rules that govern issues that are pertinent to parties. Now, again here, because lawyers like to look at details, defining what are pertinent to issues is some of the things that we'll be discussing as we progress today. Next slide, please. Now, again, looking at the Political Parties Act, when you come to Section 40, subsection 2, it requires that this tribunal, which is established under the Political Parties Act, should not determine a dispute that is brought under A, B, C, or E, if that dispute has not first been determined by the political party dispute resolution mechanism, which means that even at that stage, the law anticipates that every political party will have a dispute resolution mechanism of some sort within their structures. Now, the Office of the Registrar of Political Parties is represented. And I'm sure they will tell you, and you have engaged with them, that before the party is registered, they look at the constituting documents, and these are some of the things that they confirm as they proceed to register or give a temporary registration before the final registration to political parties, that you must have some mechanism, a constitution, laws, and rules that will be able to guide the manner within which you outline or you conduct your proceedings. Now, just before I move from this slide, again, remember that 40 subsection 2 requires that before the Political Parties Dispute Tribunal can determine any dispute under A, B, C, or E, that dispute should have been subjected to an internal party dispute resolution mechanism. Next slide, please. Now, those disputes that I mentioned in that slide, A, B, C, and E, are these disputes, the ones that are referred to. These are disputes between members of a party, disputes between a member of a political party and their political party, disputes between political parties. So where there's a dispute between Chama cha Karatasi and Chama cha Kijiko, for example, then that dispute is anticipated to have been resolved fast before, through some mechanism, before it can come to the tribunal. And then disputes between coalition partners. Now, I'm stating these particular disputes where IDRM is specifically required because there are other disputes that the Political Parties Dispute Tribunal handles, but these are not necessarily subjected to internal dispute resolution mechanism. For example, we do listen to appeals from decisions emanating from the Office of the Registrar of Political Parties, so that if the Registrar of Political Parties determines that a party, for example, needs to be deregistered, that party could file an appeal before the Political Parties Dispute Tribunal, and we could listen to that. We also do listen to disputes regarding political rights or political issues that emanate from independent candidates. When the independent candidate has got an issue with a political party or with the registrar of political parties. Like in 2017, we saw some, or I remember a particular presidential candidate whose logo, I think, was declined by the registrar of political parties, coming to file an appeal before the Political Parties Dispute Tribunal, seeking redress because they felt that the decision by the registrar was made in error. So these are the disputes that the law anticipates that before we as a tribunal can be able to deal with them, they need to first have been subjected to internal dispute resolution mechanism. Next slide, please. Now, other than what the law says, we know that in Kenya, we like to litigate matters, and we like the court to be able to interpret and make clear for us what the law intends. So there have been disputes coming to the tribunal where people felt that for one reason or another, they should not be forced to go to their own political party to determine the dispute, but they should come direct to the tribunal, which is created under the Political Parties Act, is one of the organs, just like the Office of the Registrar of Political Parties is, just like the Political Parties Liaison Committee is. So they anticipate that then they should be able to come there directly. Now, these matters being taken, the courts have determined there were a few diverse decisions that were made by the High Court, where some of the High Court decisions stated that you did not need to have done or gone to IDRM to come before PPDT, but there were some other High Court decisions that stated that you needed to have gone through or undergone some dispute resolution mechanism within your party before you came before PPDT. Now, the beauty is that now that it has gone to the Court of Appeal, because once it goes to the Court of Appeal, then we have a guiding jurisprudence that guides that. The Court of Appeal has already determined that, and the general conclusion is that before you present your matter to PPDT, when it is those matters that were listed in the slide we looked at before this, that you need to have gone through some form of political party dispute resolution mechanism. And I've stated just one of the cases as an example, because people like to quote them even when they come before the tribunal, to say we are coming here because we are told we have gone to the party and we have concluded we are not satisfied, and therefore we come here because we have a right and because the law says we can do that. So that is one of the decisions that I have cited there. Next slide, please. Now, because of this requirement that when you're coming to PPDT, you need to have gone through some form of internal dispute resolution mechanism. In 2017, together with the Office of the Registrar of Political Parties, bringing together all key stakeholders, we went through a process where we developed some guidelines. And I will emphasize again, at this stage, for the emphasis, for the benefit of all those who have currently already logged in, that the guidelines are guidelines. It is not necessarily anticipated that they would be replicated into the laws or procedures of each political parties, but that they would guide the political parties in formulating the rules and procedures that would then work for them, depending on the political party. So that is why then we developed these model rules, which are meant to cover the model rules. The scope of covering of this rule was to cover disputes that include those between members of a political party, between members and their political party, disputes that arise out of political party primaries, disputes that arise in the election or appointment into party offices and party lists, and then issues on management and administration of party funds, finances, and other party assets, so that where there's a dispute within the party membership as to the use of party funds, party finances, and other party assets, that then these guidelines would be able to apply in forming a structure that would deal with such disputes. Next slide, please. Now, other issues that the rules cover include when the parties are in the process of their management and administration of parties' non-financial assets, because there may be some, like some have office space, they have land that they may want to use. So they're non-financial assets where disputes arise concerning that the resolution of those disputes would be guided by a structure such as those that are proposed by the guidelines that we're talking about today. Now, again, on the management of party affairs, sometimes the way party affairs are managed could cause discomfort or could cause conflict amongst the membership. And it is anticipated that those are some of the conflicts or the hiccups that these guidelines would be able to ensure that we have a mechanism within the party that deals with such conflicts. Another is in relation to a political party's constitution, code of conduct, or policy document. Remember that at the end of the day, most political parties will come up, say that this is the stand of this political party, this is the policy, this is the direction. When you're going towards an election, this is the manifesto. When there's a by-election, this is our decision as to on whether to field or not field candidates for the position and etc. So these are some of the policy decisions. These are some of the key guiding or overall decisions that political parties are expected to make. And in the process of coming up with those decisions, it is anticipated that there may be some disagreements. And I'll give an example. There are some parties, for example, that felt that their party should support, when we had the BBI process, should support the BBI process. There were those members within the same political party who felt that this was something they should be totally opposed to. So before a party could come up with such a decision, there are structures within political parties of how they form that policy. And in the process of agreeing, there may be disputes. So it is anticipated through these guidelines that political parties will have structures, will have organs, will have means of dealing with those disputes, so that at the end of the day, they form a common way forward as a party and they remain united and they retain their membership, because retaining of membership is key to any political party. And then, of course, any other matter that may be incidental to it. Now, these are some of the things that the guidelines thought were important to cover at the point when they were being developed in 2017. And again, as has been said before by previous speakers before me, that the guidelines have been tested. They were tested in the 2017 elections. They have continued to be tested since then. So this is an opportune time for us to see whether even the scope of what the rules provide is something that perhaps we may want to expand or reduce. But this is where this is what the guidelines cover as at now. Next slide, please. Now, when you look at those, you find that in order to cover those areas that I have mentioned, in as far as political parties are concerned, what is provided is that there needs to be an internal dispute resolution organ. Now that organ, its functions are clearly stipulated according to the guidelines. Every party should have an organ whose functions are clearly stipulated. The composition, the criteria and tenure in office is clearly outlined, and the manner in which the organ is invoked. Do you invoke the organ by way of a letter? Do you invoke it by way of calling a meeting? Do you invoke it? Each party comes up with a clear manner that is stipulated so that any member of the party knows that when I'm unhappy with what has been going on in the process, this is the manner in which I can ensure that the dispute resolution, I think there's a dispute that needs to be resolved here. This is how I ensure that this organ is brought into play. Because we have also seen in some instances where people come and say there is no clarity within the political party as to how or where that organ can be located. We saw, for example, in 2017, where political parties had set up institutions that were to determine issues of disputes around the party primaries, and subsequently they were dissolved and the members were not aware. So you are filed, but you're not aware that it was dissolved or such things. So these are things that we are saying need to be clear in the guidelines and the rules and procedures of each political parties. Now you can see from what the guidelines provide, when you look at that part, that the rules anticipate that there will be an organ with an identified mechanism or person where all concerns or issues that need to be raised for purposes of dispute resolution can be channeled. Next slide, please. And to deal with this, when you look at what the guidelines offer in as far as the internal dispute resolution mechanism is concerned, Part 3 provides for qualifications of the members, disqualification. They talk about having a secretary, a permanent secretary, so that if, for example, in your political party, issues of dispute resolution are addressed to the chairman of the party, or they're addressed to the secretary general of the party, or they're addressed to the party leader, then perhaps when you're going to make the rules for dispute resolution, you would say that the secretary to that dispute resolution organ is also the chairman of the party. So you're chairman, but secretary for purposes of dispute resolution. Now, again, in Part 4 of those guidelines, we give procedures. That is, how do you invoke, like I said, how do you invoke that internal dispute resolution organ? Is it by request? Is it by a form? And then how does it commence its sitting? Because it should not be secret that I had a dispute. I had sent a letter to the secretary of the organ, but nobody ever told me. But the organ is saying we sat and we determined. So how the organ commences its work should be clearly stipulated in the documents of each political party, and then how the process terminates, including the decision that will be made by that organ, and what recourse you have once that decision has been delivered should be provided within the organ. Now, other than that, there is also the requirement that in having an organ that deals specifically with issues of dispute resolution, there must also be procedures or processes with regard to elections and nomination disputes. And this was recognized because you remember that the timelines are normally a bit constrained when it comes to by-elections or the general elections where parties are concerned. So it then becomes very important that clear regulations and rules are made for that, so that if there's an ordinary dispute about a certain policy process and it requires, say, 2 weeks notice, 10 days, you know, you may not have that kind of luxury if it is a party primary or it is during general election or a by-election. So you may change the timelines for purposes of that procedure. That is what the rules anticipate in as far as an internal dispute resolution mechanism is concerned. Next slide, please. I hope I'm still being heard.
Yes, Honorable Lwanga, we can still hear you.
Thank you.
Yes, you're loud and clear.
Okay. Now, the next part that the guidelines cover is the need for an internal disciplinary organ. Now, I'm laying emphasis on the word disciplinary because most parties tend to have a disciplinary organ, but do not have a dispute resolution mechanism. So it is important to note that the guidelines require that at any one time, you must also have a disciplinary organ, an internal disciplinary organ, so that if, for example, a member has been trying to resolve the disputes, the dispute has been resolved. Remember that the mantra for democracy is that all must be heard, even the minority must be given an opportunity to express their views, but then the decision goes with the majority. So if that person has gone through those organs internally and has tried to raise it, but they still continue to be a headache or not adhere to the issues that the party has determined, then they may be taken through a disciplinary process. So it clearly shows that there needs to be some kind of, it may be thin, but there needs to be some kind of demarcation when you're dealing with dispute resolution, when you're trying to resolve the issues within the party, and at the point when you're disciplining the members, and you're now taking them through a disciplinary process. Now, when you look at those guidelines, the guidelines try to or anticipate an organ that is very similar to a court, because it talks about the need to have a register so that there's clear record. Remember that everything we do when it comes to the justice process refers to the need to have records, to keep records, so that again here we are talking about you being clear about the filing fee. We saw, for example, in 2017, some political parties not being very clear about how much you should pay when you're filing a complaint in reference to certain issues. So clear fee, forms, samples, everything clear in the process, including at what point the rules that this organ must be must adhere to, so that at the end of the day, it becomes easier for any party to be able to appeal if there's a problem, if one of the rules or some of the rules were not followed or adhered to. Next slide, please. Now, this internal disciplinary organ under the model guidelines anticipates the establishment, clear identification of functions and tenure of the persons who will sit in that organ, having the registers, I've said, and including a process where the rights of parties in a disciplinary process are protected. So that, for example, there will be clear indication as to how service is effected, what notice you need to be given, your right to be able to appear, even with counsel if you so wish, your right to be able to produce witnesses, your right to know what is the accusation being labeled against you, and then including telling you what is the way in which you can appeal the decision by that particular organ. So these are the broad guidelines, detailed, because again, when you're giving guidelines, if you leave out something, people may think it is not important. So that is why they're that detailed. Now, from these guidelines, each political party is anticipated to pick a structure that best works for them, given their circumstances, because it is the members of the political parties who know best what works for their political party. Next slide, please. Now, in having developed these guidelines just before the 2017 general election, having seen them used, and again, like I said in the first session we had in the morning, I'll repeat again now. I remember in 2017, one of the political parties, if I'm not wrong, it was ANC, coming to our offices to even show us how they had adopted these guidelines within their procedures and laws. So having seen that parties were already beginning to incorporate them and apply them, I wanted, as we go towards the conclusion, to look at some of the positives we have noted as far as these guidelines are concerned, and the gaps that we have also noted. We have noted that increasingly over time, a number of parties have been applying the guidelines. They have clearly stipulated processes in as far as dispute resolution and discipline is concerned. We have noted that to an extent, at least members are beginning to adhere to it. The instances when we had people feeling that anytime you had a problem with your party, you are expected to quickly rush to the tribunal or go to the courts, whether it is the magistrate's court or the high court or whichever court you felt you needed to go to, are reducing by the number. more and more people will only come to the tribunal after they have tried to resolve the issue within their political party. We have also seen that to a large extent, a number of political parties are giving us written decisions or findings. Now, if I may digress for a second here, I will tell you that in 2017, when we had an MOU with IEBC and we were expected to handle all the disputes arising from the party primaries, one of the things that we were told by one of the former commissioners of IEBC who had dealt with disputes, the time IEBC dealt with disputes in 2013, was that there's no time, there's too much pressure. You don't have time to write decisions. So just write a one paragraph thing so that somebody can go and attach it to the appeal if they want to appeal to. There's no time. But under the instructions of our chairman then, we did endeavor as much as possible to come up with decisions, because if you have a written decision, then when someone goes to appeal, it becomes easier for the appellate court, whichever it is, whether it is the High Court or the Court of Appeal, to be able to see what was the thinking and then see where the gaps may lie. Now, we have also noted that over time, parties are adhering to their own, to the decisions that emanate from these processes, at least to some extent. Now, however, there's a gap that we have noted, the issue of, and I did allude to this earlier, the demarcation between discipline and dispute resolution. So that you find a lot of political parties have got disciplinary organs that are constituted, and there's clarity on how they should be constituted, but they do not have a dispute resolution mechanism that members are able to channel through. Of course, there are organs, and these organs have meetings, and the organs have specific members, and they make certain determination. But the level and extent to which participation, which we know is a key principle, or in the Constitution, participation of all the members is ensured, so that even as these organs determine, people feel that the decisions are theirs, may be a bit blurred. And that is why you find that people come, and every time they come, it's as a result of a disciplinary process, and hardly ever as a result of a dispute resolution. When they have disputes, most of the time political parties express frustration that the laws say that this organ will determine, and the organ has determined. And when it was determining, nobody involved us. So what do? The only recourse we have is to come outside the political party and come to the tribunal. Now, we have also noted that there still remains, to an extent, limited knowledge and use of some of the processes and laws applicable, particularly, of course, the principles that are outlined in the Constitution, the Political Parties Act, the Party Constitution, the Fair Administrative Action Act. Remember that I did mention that the disciplinary organ is seen to be something like a court. The dispute resolution organ is a standing organ that can be identified and whose systems are clear. So they're expected, as in line with what the Constitution anticipates, that every action they take, they will incorporate the principles of fair administration, where they will be give notice, the process will be transparent, it will be clear, people will be given an opportunity to be heard, whether it is through a dispute resolution, because you can't be attempting to resolve a dispute if you don't hear all the parties, and you can't be subjecting somebody to a disciplinary process if you do not give them an opportunity to perhaps defend themselves. So these are some of the gaps that we have noted. Next slide, please. Now, just as my final remarks at this time, I thought it would be important to highlight some of the reasons that PPDT has had when they have had to dismiss cases. And just for emphasis for purposes of clarity, that these decisions apply on both sides, sometimes towards the political party, sometimes towards the member. And here, wrong organ. The wrong organ is the one that is, the wrong organ is the one that is taking action. You find that the political parties have identified that when there's dispute, or when there's a disciplinary process, there is an organ that is named this that is supposed to conduct this process. And that organ is supposed to be chaired by a certain person, and its membership is, as an example, 9. And for purposes of quorum, if there are 5 members, they have quorum to proceed with the proceedings of that day. Now, if then a person is being subjected to a disciplinary process or a dispute resolution process is being applied, and an organ that is chaired by not the person named in the law, it is not constituted in the way that it is stated in the law, then you find that it's the wrong organ based on the law of that political party. Sometimes, again, related to that, it's a wrongly or improperly constituted committee that was sitting and listening to that. Again, on issues of fair administration as administrative action, you find that maybe there was not enough notice given to somebody. And this is why I said, in the process of making the rules, you must make rules that take into account normal, in quotes, circumstances, and of course, other abnormal circumstances. Right now, we are, of course, in COVID times. I know many people are looking at their policies and documents to take into account the COVID times, but including also during elections, whether it is a by-election or party primary, because the time limits is short. So that if normally you have 10 days, maybe you need 10 hours for purposes of a party election to give notice. Those are rules that are developed with the membership in agreement. Your members know them, the party organs know them. Then non-compliance with their own procedures. If you have set out a procedure as a political party and say, this is how we need to go about it, then if you do not adhere to that procedure, then there's no option other than to dismiss that process as having been null and void. And I give an example here, again, of, say, some political parties that have very elaborate rules and then require that in order for a determination to be made, an organ needs to be constituted, and that organ has 40 members. And the 40 members are drawn from all over the country. Now, if these people have to come for a physical sitting for purposes of that process to occur, and we know the resource issues, maybe you can't get all the people at the same time, or there's no resources to be able to facilitate attendance or the requisite quorum, then you find that you cannot comply to your own procedures. And it is the party itself with the membership that developed these procedures. It becomes, our hands become tied. We have no option but to dismiss. And then, of course, the standard one, where there's been a breach of fair hearing, where a person has not been given any opportunity to be heard or to even present their witnesses or even to appear with the assistance of counsel. So you'll find that these are some of the circumstances that have led to our dismissing certain applications or certain cases. And it is at this juncture that I think maybe I could stop and hand back to Mr. Wet so that she can move us to the next level. Thank you for your attention.
Thank you so much, Honorable Mwanga. That is a lot of insight about PPDT and how political parties should conduct their business, especially the internal dispute resolution mechanisms. Now, welcome to those who joined us, maybe a bit late after we had begun. You can kindly introduce yourself in the chat box session. Just say your name and which political party you represent in this discussion. And also, if you have any questions, also I would like you to write them down at the chat section. I will raise them with the appropriate person. There's a question already that has come in, and it is Peter Dubai from DP asking, do we have timelines within which disputes shall be resolved? And then Marco Siche is asking if we can get the PowerPoint presentation. I'm sure Maureen can organize for that. So welcome again once, and then back to you, Honorable Millie. You can just answer Peter. Do you have timelines as PPDT in which disputes should be resolved?
Hello, you said we could introduce ourselves.
No. Hello, you can introduce yourself at the chat section. You just write your name and which political party you represent. Because of the interest of time, we are not able to introduce ourselves. I'm sorry about that.
Shall I go?
Yes, please, Honorable Mili.
Okay, thank you. Now, just for clarity, the Political Parties Act requires that the Political Parties Dispute Tribunal resolve any dispute that comes before it within 90 days from the date that the dispute is presented before it. So we have very, very tight timelines within which we have to conclude our processes. But for purposes of the discussion we are having today, we are talking about the model guidelines that would guide parties. Each and every party would then have their own rules. And I have seen for some of the parties where cases have been presented before us, that parties have their own rules as to by when they need to have concluded a matter, by when a decision needs to have been delivered to the party, to the person who was being taken through a process, or when the dispute resolution mechanism must then channel its dispute to the next level. So parties develop for themselves, amongst taking into account their circumstances and understanding their membership and their needs, will develop for themselves rules. What the guidelines say is that there is need to be clear, so that it is not left as a pata-potea kind of situation that you are not sure when this decision will be delivered. But it is important to have guidelines that would be able to help this. Because remember that these processes are meant to, it's like a staircase. If you have concluded the processes, and a number of political parties have got processes that start at one level and then can be escalated to a higher level, maybe to a more national level, or a level that brings in more national offices. Now, once it has moved through that, then it can move to the Political Parties Dispute Tribunal. And remember that that is not the end. At the end, when the tribunal makes a decision and a party is still, or a political party or a member is still dissatisfied with that decision, they can move to the High Court. They can still again move to the Court of Appeal. The good thing is that now there's been a decision that says that some of these decisions on political party disputes need to end or terminate at the Court of Appeal level. So at the Court of Appeal, they can still move to the Court of Appeal. So there's still that journey to go. So it becomes important for one to have determined timelines, so that then justice is not just done, but is seen to be done.
Okay. Thank you so much, Honorable Lwanga. And then another question that has come to my inbox is, does PPDT act as an oversight to political parties to ensure that they come up with these some of these mechanisms that you have stated in your presentation?
I'm glad that Mr. Makolwal is here. I'm sure he will respond to that one. So I'll leave it to him to respond to that. But for us as a tribunal, what we felt was that since the law, the Political Parties Act, requires that we must determine that some process had been done at the party level. The courts, as I've already stated, have also confirmed that we must determine that some process had been done. We thought it best to give some guidelines so that as political parties come before us, then there'll be at least some kind of standardized form of addressing disputes within political parties, of course, tweaked to the style and design of each individual political parties. But maybe at this juncture, it would be good to have Mr. Makolwal comment on oversight of that. And remember, the guidelines were developed jointly. Yeah.
Okay, thank you so much, Honorable Lwanga. Mr. Ben, I would like you oversight issue. Ben is here as a representative from the Office of Registrar of Political Parties. So maybe you can take up from where Honorable Lwanga has concluded. Welcome.
Thank you so much, Madam Chair, and thank you so much, Honorable Mili Lwanga, for such an elaborate presentation on the model rules. to start the discussion, it's important to underscore one fact that in any democratic governance, parties are very important and therefore very, very fundamental aspect of democracy. And it goes without saying that it is necessary to add that a single party state is an essential root of tyranny. That is the reason why Kenya is a multi-party democratic state. And it is true that disputes cannot be wished away where political parties are, because political parties in themselves, they are meant for competition. Now, to answer the question of oversight, the registered political parties has the mandate of ensuring the compliance of the political parties, that they are compliant with the political party. The political parties are compliant with the Political Parties Act, each and every provision under the same. There are two major sections that brings a lot of disputes when it comes to the management of political parties. That is one, the enforcement of Section 20 of the Political Parties Act that deals with the change of particulars, change of constitution, change of officials, change of party locations, and the rest. That is the one area that brings a lot of disputes that comes out when you talk of political dispute resolution. The other area is Section 14 that deals with the deeming aspect and the discipline as it is. And to be specific, you will find that Section 14.7 is very categorical that a political party, yes, they have the right to discipline their members in line with their individual constitution, but it is a mandatory requirement that that member must be, there must be a demonstration that he has been given an adequate time for fair hearing. So that is where we come in on the part of oversight, that when a political party presents or submits to the office of the political party, that so and so should be expunged from our membership list. Remember, we are the custodians of the statutory custodian of the membership list. What we will always look at is, as of the political party complied with Section 14.7, that requires that that member must be given a fair hearing in line with their constitution. Now, on looking into how the dispute arising from within political parties have affected the ORPP discharging its mandate. It is true that whenever there is a dispute within a political party, it affects on how our office will carry its oversight mandate over that political party. For example, if there's a dispute in terms of leadership of a political party, where there is a problem of who should be the Secretary General, for example, of a political party, it will be very, very hard. Remember, the political party is set up and structured. It is the Secretary General that is the accounting officer. It is the Secretary General that always have recognized their correspondences. The bridge between our office and the party is called the Secretary General. So if there is a dispute on leadership structure of the political party, on those officials that indeed should be the serious signatory of some of these statutory forms, it's always becoming a problem. For example, if there's a problem in the leadership and the political party is meant to participate in elections, it becomes a problem in terms of how to do the same. And that is how the oversight part of it comes very well, that it is the role of them and the mandate of the Office of Registered Political Parties to oversee that the political parties are in compliance with the entire Political Parties Act and how to manage going forward. Now, another area that now there's a very big dispute and a very big challenge with us, and I discussed it in the morning, is with regards to the COVID-19 and the rules that comes with it. Most of the political parties' constitutions, the architect was on the basis of physical meetings. And you remember that even right now, there are some of the political parties that are trying to change and amend their constitution to embrace the virtual meetings. And that's why, as an office, we are now in the process of developing the guidelines the virtual meeting guidelines of how political parties can carry out their activities in line with not necessarily having physical meetings. And that is an area that we take very seriously as we move forward. And we know moving forward by the end of the election, by the time we are going to the election, political parties, because having some of these meetings and some of these dispute resolution are compliance based, they are mandatory. That they must be done. And if the political parties cannot meet, for example, Wanga was talking of a political party that has got a membership of 40 people. And remember, you cannot have 40 people having a meeting. So it's always important for us to do moving forward towards that direction. Another area that is also affecting our mandate seriously right now is the new norm of the coalition structure and arrangement. You remember the political parties, they have the right to have coalitions of same-minded and in terms of ideology with other political parties. It is now that the disputes are coming in that how to handle disputes that are rising between the coalitions and how to handle disputes that are rising out of an individual member of a political party having a problem with the decision that has been made by a coalition structure kind of a political party. And that is those are the small areas that we are working on, but we believe that moving forward, with the engagement of the PPDT, the engagement of CMD and other like-minded stakeholders, we're very, very sure that we are going to move and improve on these model rules. It is good that our office has been part of this development of these model rules 2016 up to date, and we are very, very sure that we are ready to move forward and have a amicable way that we can have our political parties as public institutions. And it's good that the Kenyans are embracing that right now that political parties are indeed public institutions that must be given some bit of leeway and governance structures as provided for under the 2010 Constitution. Thank you so much.
Thank you so much, Boniface, for that insight and input from our RPP. As we know, it is what governs the political parties and gives direction. Now, there were two questions of the chat box that had been asked, and I am seeing Margaret Ndanyi's hand is raised from ANC. So I will give you a chance shortly. The first question is from Peter Ndumbai. Most disputes occur during party primaries, and 90 days is not sufficient for its resolutions. I'm assuming that's what you meant. And then another question from Mark, and I think this is directed to Honorable Lwanga. What is the tenure of PPDT? So before you answer that, I will give a chance to Margaret Ndanyi to ask her question. Thank you so much. Margaret, can you hear me? Margaret? Margaret, if you can hear me, kindly just unmute your mic and ask your question. Okay, Honorable Lwanga, maybe you can go.
I'm there.
Okay, sorry.
I'm there.
Okay.
First of all, I just want to thank Wanga for taking us through this very, very comprehensive session. It is very, very informative, and she has clarified quite a number of things that have been bothering parties. Nevertheless, I would like her, or rather, I want to put it very candidly, that there are times when political parties have actually had internal disputes with members, and they have tried to solve it internally, but these members ran to PPDT. Now, instead of PPDT sending them back to the party, they make a ruling. We have a case of a member who we called this member for over 20 times, writing letters, inviting the member to come to the IDRC. They never showed up. but they went to the PPDT, and PPDT ruled in favor of that member. So what I want to put across is that, please, PPDT, we would like to partner with you and work with you properly. Listen to political parties. Let political parties solve the internal disputes amicably. Don't be the one to have the political party. And if a political party is fed up with a member, PPDT, you have no mandate to insist that that particular member should be brought back to the party. So what I'm saying is, you are doing a great job, but can you also let political parties conduct their activities in their parties without interference from PPDT? Thank you.
Thank you so much, Margaret Ndanyi, for your question. And Honorable Lwanga, before you go, there's another question from Tony Muturi, and I can see his hand up, but I will first read the question. Thank you, Honorable Lwanga, for the presentation. ODM is one of the biggest clients of the PPDT and the guidelines. The tribunal has handled the question of jurisdiction very well, and this will enable parties to put into use their internal dispute resolution mechanisms. Area of reform, implementation of the section 14.5 of the Political Parties Act. How do you deal with a rogue member of the party who violates the tenets of the sponsoring political party and seeks refuge in Article 50 and Fair and Administrative Action Act? And then Ben Shihanya has also has a suggestion. Can you also prepare guidelines on virtual disciplinary processes, at least some components of it? And he says, thanks for the great presentation, Honorable Lwanga. So maybe you can begin. Well, sorry, we can begin with Tony Muturi. I saw your hand up, and then now, Honorable Lwanga, you can come in and address some of the questions that have been directed to you.
Thank you, Coach and CMD for organizing this. And thank you, Honorable Lwanga, for taking us through or illustrating what the PPDT does and how we can partner with political parties in terms of trying to mainstream our programs and activities. Indeed, I summarized my question, and it's good that Madam Margaret from ANC has raised this pertinent question, and I'll be very, very brief on it. In respect of going forward, the issues that we have been having as political parties, either with our members who present cases or disputes to the PPDT, and in some cases that you will find that they get orders, which in any case leave the political party at a loss. And my major problem, as I've indicated, is the implementation of Section 14.5, and it's good my colleague Bon Makolwal has raised it. It's proving to be very, very difficult for political parties to discipline their members, looking at the latitude they have in terms of their rights as provided in the Constitution, and also to various pieces of legislation. And the only way I think we can go through this continuum is to have a tripartite session whereby the PPDT, political parties, and the Office of the Registrar of Political Parties come together, sit and look at these issues from a very practical perspective. Because it becomes very, very difficult to have a member who, by all intents and purposes, has decided to leave the nominating political party, but uses or finds refuge in provisions of law to keep on safeguarding his or her position to the detriment of the party principles and ideals that the nominating party decided to allow this member to run on that party. So PPDT is doing a good job, but my concern will be it will not achieve much if the decisions that are rendered by the PPDT are not in congruence with the ideals these political parties are premised on. A tripartite meeting, for me, will be very important, so as also PPDT members can understand what us as political parties will go through when we come to a situation whereby we have made a decision to chase away some of these members. I think that's the way forward I would have recommended.
Thank you so much, Tony Muturi, for your insights and your questions as well. Honorable Lwanga, back to you. I see most questions are being directed to your office. So if you can hear me, kindly come in.
Okay, thank you very much for those insights, including the comments and questions. They're taken with very good faith. Now, one thing that I would again lay emphasis on is, as I heard earlier, is on the issue of timelines. When it comes to the law already as is, unless the law is amended, and amendment happen in parliament. And in parliament, it is your members as political parties who sit there. So unless they amend the timelines, but as it is now, we have 90 days when a matter is filed before us that we have to conclude it. It is not easy for us also as members of PPDT, because we are not there on a permanent basis. So we have to juggle our diaries, be able to form a quorum, because any decision of PPDT requires a 3-bench membership. So to juggle that diary and get that, and with the limited time, and you're also juggling the lawyers representing the members and the political parties, and sometimes Makolwal is there, he knows. Sometimes Makolwal's office is also there, and they also have a diary to keep. So juggling these dates within those timelines and their applications before the final complaint can be tight. And again, this is made worse when we have party primaries during election time, whether it is a by-election or the general election. Because remember, the timelines during that time are set by IEBC. And IEBC is going to say that political parties must conclude their primaries by this date. And then they say, PPDT, you must listen to all appeals from decision of political parties by this date, so that the High Court can conclude by this date, so that they have a clear record, so that they can send to UK or Paris or wherever it is they do to be able to develop the ballots. Now, having said that, those timelines again are set by law and IEBC, and we as a political party have to work within them. It is very constraining. So it would be useful within the political parties themselves to set realistic timelines. If you know that your parties are likely to have a very emotive primaries, maybe if you did them early enough so that you have enough time as a political party to resolve the processes before they have a right, because it is a constitutional right to be able to move outside and exhaust all avenues of litigation or of justice. They can come to the tribunal, they can then move from the tribunal, go to the High Court, move from the High Court, go to the Court of Appeal. That is their right, that is everybody's right. As a political party, it's important for us to set those. I said it in the earlier presentation, I'll repeat again now. What we saw some of the political parties do is that in the party primaries, they retained all the decisions until the very last day that political parties were supposed to have finished, and PPDT was also supposed to have given all their decisions and then released them on that day. So people had to rush to court, the High Court insisting that we open, retired Judge Maraga insisting that we stop because we will mess with IEBC timelines. It caused a total mess. So it's important for timelines to begin right from the party process. Now, the next question as to guidelines, we take it, of course, in good faith. And as Makolwal has also said, it's important to amend these guidelines, even with the lessons learned, to see how much more practical they can be made. But remember, again, I will repeat, these are guidelines. Every party should use them to make up a structure or a process that best suits their circumstances. It is not about applying the guidelines word for word. It is about understanding the principle of it and then being able to ensure that the key things can be answered. If someone asks, is there an organ? There is. How is that organ constituted? It is there. So those are some of the things that have to be taken into account. Now, the frustration that people have, remember that once you move outside the political party, and that's why for us as PPDT, we lay emphasis on the political party first resolving the dispute. Once you move outside it, there is no win-win situation unless you settle and come and record as consent before the tribunal. There's always got to be a lose-win. And that is the same thing when you go to the High Court, and even if you go to the Court of Appeal, there's got to be a winner, there's got to be a loser. So there's got to be somebody who's dissatisfied. Now, what I'll say again, like I did say at the beginning, is that what we have noted is that some political parties developed very, very elaborate processes to deal with their issues. Now, when the processes are very elaborate and then you do not follow them, there is a gap. So if you say, for example, this must be done and after that, this must be done, then you don't do them. You decide to apply a shortcut, then there's a gap. Now, there are other political parties that have developed in their rules and in their laws, they've made, provide for an option where perhaps some kind of, I don't want to call it a shortcut, but an alternative process can apply in circumstances where it is justified to use that. So where they have used that and it is supported by their own rules and laws, then you find that it is possible for the system to stand. But where you have a very elaborate process of how you deal with issues of discipline within the party and you do not adhere to it, and most of these people end up employing lawyers, and lawyers, it is of course their work to look for the loopholes, and they find those loopholes. They will be able to show that there were loopholes that were or steps that were merged or jumped or that were not complied with according to the rules of the party. Remember that PPDT does not apply rules outside the party. We look at, and that is why when you file a complaint in the tribunal, the requirement is that you must also file the constitution of your party. Because where they have not filed, we have, for example, requested the Registrar of Political Parties to give us a copy of the constitution that is registered with them for that political party so that we can see. Because we cannot determine that somebody did not follow the process if we don't have the law that determines what the process is. So where you find circumstances arising, you find most of the time it is within the elaborate rules and regulations that are outlined in that particular structure. And where those are followed to the letter, our hands are tied. At least at PPDT, our hands are tied. If you followed your process, then it stands. If you did not follow your process, then we say you have to follow the process. I think that I've answered most of the questions that came up. Back to you.
Luanga, you have. The only one you left out is how long is your tenure?
Oh, yes. Sorry. If I can quickly say that. When JSC recruits members of the tribunal, they are recruited for a single non-renewable term of 6 years.
Okay. So, Mark, I think your question has been answered. And then just as a highlight to some of the issues that Honorable Luanga has spoken about is political parties need to give members of their party clarity on the composition, dissolution, or termination of their IDRM, the decisions that are made, keep clear records, and then timelines, like she has emphasized on, should begin from political parties because what they have is set in law and they cannot go beyond that. And then what they have given us today is guidelines by them to political parties to try and see how they can use them to come up with their own internal mechanisms. That has been all so far. If you have any questions, you can kindly raise your hand. I will give you a chance to ask your question, or better yet, you can type it in the chat box and we will direct it to whoever is responsible for that. So thank you again for tuning in to our participants, and thank you to CMD for organizing this meeting, Honorable Luanga from PPDT and Boniface from RPP for also joining us in today's session. So any questions? Maureen? Maureen from CMD, if you can hear me. Maureen?
Yes, Chair.
From our side, I think we are almost coming to an end because most of the questions have been
Chep, I cannot actually hear you well.
Oh, sorry. Can you hear me now?
Yes.
Oh, sorry about that. I was saying that from our side, with our two presenters today, that is Honorable Luanga PPDT and Boniface ORPP, they have answered most of all the questions actually from the participants, and I believe that I have not left anyone out. If you have a question, kindly raise your hand or put it in the chat box. Meanwhile, Maureen, you can back to you. You can take it back.
Thank you so much, Chep. I hope you can hear me well. I think there's a time I dropped off, but I'm now back. Thank you so much for that moderation. And I hope you're not closing anyone out, even as we move to the next session of just asking Mr. Bon Makolwal and Honorable Luanga to just make their final remarks. Maybe we can give it participants around a minute or so to just see that to ensure that we're not closing anyone out with a question. But just in case a question comes up with a member, they are at liberty to just text or email it to us. We shall forward it to either Honorable Luanga or Mr. Bon Makolwal for addressing. So on that juncture, let me just give it back to Bona Makolwal to just make his final remarks, and then I give it to Honorable Luanga before we finalize the meeting. Bona Makolwal, your last words, if you can hear me.
Maureen, thank you. My name is Wakoko. I'm standing in briefly for Mr. Makolwal.
Oh, hi, Wafula.
Hi, Maureen. His part in short was that the issues we are having now, some of them can be sorted through the legal reform agenda. And this is the period where our office and other duty bearers are engaged in the legal reform process. So these are the issues we can iron out and present towards legal reform. Thank you, Maureen.
Thank you so much, Wafula Akoko from RPP for stepping in for Mr. Bon Makolwal. Thank you so much. That is well noted. And as I was saying, just in case we get any other question from the participants, I think I'll be reaching out to you or to Mr. Makolwal so that they can address it. So let me give this chance to Honorable Luanga to just wind it up.
I must, of course, thank again CMD for organizing this great meeting and session where we were able to look at these model rules. We cannot overemphasize the concern that we have heard as a tribunal when it comes to the manner in which political parties have crafted their own rules and regulations, and where we see potential frustrations when it becomes very difficult for them to adhere to those own rules. I think it would be opportune time for political parties to look at them and have realistic guidelines that would be able to assist them. Makolwal did say earlier on, I'm not sure if he did in this session, but he did say in the earlier one that even now, having rules that allow it to be considered a proper meeting, where the meeting was hybrid, part virtual, part physical, to enable attendance. It may even be able to address the concerns that have been there for some of the political parties, which have got elaborate processes, require 40 members to sit and sanction an action, and that is not done because it is not possible to do it sometimes. So we continue to emphasize that you develop rules that you know is easy for you to work with, because our role as PPDT is simply to ensure that those rules that you developed are adhered to. And where they are not adhered to, then we say that they were not adhered to. And if you do not agree with our findings, the High Court and the Court of Appeal are happy and there to be able to either uphold or convert the decisions that we have made. I just want to say thank you once more and hope that we continue this useful engagement even as we move to the next general election, so that party primaries will be completely and entirely resolved largely within the political parties, and we reduce the number of complaints that come to PPDT. Asanteni.
Thank you so much. Thank you so much, Honorable Luanga, for being with us and facilitating these meetings with the various political parties. For the morning session where we started the meeting as from 10 to 12, and also for tuning in for this afternoon. Thank you so much. We do not take you for granted, and thank you because you have enlightened political parties on the model rules, and I hope that even as we move towards the general elections, and having come from a background where we have reviewed, we have assisted various political parties to look through their internal election and nomination rules, I'm sure that they are going to at least, pick a few things from the model rules and also input them into their dispute resolution mechanisms, so that we can ensure that we have at least proper systems in place, so that even if we have disputes within the political parties come next year, when most political parties are going to conduct their party primaries, at least those disputes can be resolved within the political parties and not, moving all the disputes to the PPDT for determination. So without so much further ado, let me just say thank you so much. Thank you so much for being here today. Even for our participants, you've been good participants today. We have not had a lot of interruptions from you. Asanteni sana for attending today's meeting, and I hope that we will continue to engage with your political parties even as we move towards 2022 general elections, to ensure that we have in place proper systems and proper guidelines that are going to guide the political parties. From us here in CMD-Kenya, is just to say asanteni sana, and we wish you a lovely afternoon. Thank you so much and goodbye. We are free now to leave at our own pleasure, and just in case you have a question, you're free to reach out to us for addressing. Thank you so much, and kwaheri for now. Thank you.
Thank you, Maureen. Bye.